So a little bit about me. I'm a criminal defense attorney, but not your normal criminal defense attorney. I don't have a generalized criminal defense practice. All I do is use of force law, meaning defense of yourself, defense of others, defense of property, period. I don't do DWIs, I don't do shoplifting, only use of force law. It's all I've done for 34 years now as a practicing attorney. To my knowledge, I'm the only attorney in the country that has that focus on just use of force law. It's important to keep in mind that once you go hands-on in that fight, once you're engaged in that fight, you've just incurred two risks you were not incurring the moment before you got engaged in the fight. One of those is a risk of dying in that fight, right? We come here to reduce those risks of dying in the fight as close to zero as possible, because we learn how to shoot. Hopefully you do something like BJJ, a variety of skills, tools, techniques, but the risk is never zero, right? No one's invincible. It could just not be your day. The other risk you incur suddenly is a greater than zero risk of going to prison. The stuff I teach, the representation I afford clients, we reduce that risk of going to prison as close to zero as possible. But it's never zero. Innocent people go to prison all the time. So our goal, of course, both for the physical fight and the legal fight, is to get those risks as close to zero as we possibly can. But it's never, in fact, zero. So what is self-defense? We think of self-defense as a physical act. That's what we're all training to do here. But from a lawyer's perspective, self-defense is a legal defense, a legal argument you raise to a criminal charge. So you've used force against somebody, you killed them, you maimed them, you caused them some injury, you frightened them with a gun but didn't even hurt them at all, didn't so much as scratch them. That's good for a felony charge of aggravated assault with a deadly weapon, 10 to 20 years in prison. And against that criminal charge, you're going to say, well, I did it in self-defense. And your lawyer will argue the legal defense of self-defense. And the nice thing about self-defense, there's a lot of nice things about it, is that it's what we call a perfect defense, meaning if your claim of self-defense is successful, it doesn't just reduce your legal liability. What you did simply wasn't a crime. But it's a very binary defense, meaning it's like a light switch. It's on or off. Either you qualify for lawful self-defense and you committed no crime and have zero legal liability, or you don't, period. And you have 100% criminal liability. There's no middle ground. It's also what we call a defense of confession and avoidance. So it's different than many other defenses, like an alibi defense, right? An alibi defense is, hey, it wasn't me. I was someplace else. I was at my mama's house. You got the wrong guy. That's not what you're saying when you're claiming self-defense. You're not saying it wasn't me. You're saying it was me. I shot that guy. I killed him. But I did it in lawful self-defense. Well, the problem now is if the prosecution can overcome your claim of self-defense, what's left of this sentence? Just, I shot him. And that's just a confession. And the prosecution knows this going in. He knows it's going to be a self-defense case. He doesn't actually have to prove the crime. He doesn't have to prove the underlying physical conduct that is a crime. He doesn't have to prove you shot that guy because you volunteered that. He just knows he has to overcome your claim of self-defense. And if he can do that, it's an easy conviction. So that's what he's looking for. When he gets that investigative report from the detectives, he's looking for some vulnerability in your anticipated claim of self-defense that he can overcome. And if he can do that, it's an easy conviction. And prosecutors like easy convictions. So the good news is that you don't have to prove self-defense. The prosecution has to disprove self-defense, and they have to disprove it beyond any reasonable doubt. Now, we've all heard the phrase reasonable doubt, normally in the context of they have to prove you guilty of the crime beyond a reasonable doubt. That's the highest threshold of proof we have in the law in America. Imagine it's 90% of the evidence is against you. Well, the prosecution has to prove by 90% that it wasn't self-defense, meaning the jury ought to be instructed if they only think there's an 11% chance it could have been self-defense, that's an acquittal, if your defense attorney knows enough to instruct the jury on that. So what is self-defense? As a legal defense, it's made up of 5 legal elements, like a recipe has ingredients. Not 500 elements, that's the good news. There's not 50, this is not rocket science what we're talking about here. There's only 5 things you have to keep in mind for a lawful case of self-defense, and often not even 5, because often 1 or more of these are not required, depending on the state, depending on the circumstances. But the most elements you have to worry about is these 5. Innocence, imminence, proportionality, avoidance, and reasonableness. So innocence means you can't have been the aggressor in the fight, right? Self-defense is intended to allow you to defend yourself against someone else's aggression. If you started the fight, if you were the initial aggressor, can't be lawful self-defense. Imminence means that the threat you're defending yourself against is either actually occurring, you're getting beat, you're getting shot, or it's immediately about to occur. So you don't have to wait to be injured before you can defend yourself, but it can't be a past threat that's over. Someone hit you yesterday, and now you're striking back. That would just be retribution. It can't be a speculative future threat that may never happen. So somebody says, I'm going to go home and get a gun and come back here and shoot you. Well, if they come back with the gun, they may be an imminent threat. But them verbalizing their future intention would not be an imminent threat in the moment. Proportionality basically means you can't use deadly force in self-defense, like all the guns we're using here, unless you're facing a deadly force threat. So if someone's shoving you, that's probably not going to cause you death or serious bodily injury. So going to the gun in defense of a shove probably would not be a proportional legal response. Now, could it be? Sure. Is the person shoving you, do they outweigh you by 150 pounds? Are they a large man and you're a small woman? Is there some aggravating factor that would make their physical aggression towards you something that could potentially cause you death or serious bodily injury? If the answer to that is yes, well, then it's a deadly force threat. But you'd have to be able to convince a jury of that aggravating factor. Avoidance, this is the element that's most commonly waived. Avoidance has to do with whether or not you have a legal duty to retreat before you can defend yourself. There are only 11 states that impose this element of avoidance. 39 states are stand-your-ground states, either by statute or by case law in those jurisdictions. That said, I would urge all of you, if you have a safe avenue of retreat, I don't care if you're in a stand-your-ground state or not, if you can safely simply walk away from that fight rather than get in the fight, why wouldn't you do that? Because, as I already said, the moment you get engaged in that fight, what have you just done? Incurred a greater than zero risk of death and a greater than zero risk of going to prison for the rest of your life. Now, are there things worth dying for and going to prison for? I would say yes, right? I think of my wife, my kids, my parents. Then I run out of shit that I'm willing to die or go to prison for. So there are things that are worth those risks, but it should be a pretty limited list. I just want you to be able to make an informed decision about the risks that you're incurring. And reasonableness. Reasonableness essentially means two things, really. One is that you had a genuine good faith belief in the need to act in self-defense. If you don't think it was self-defense, obviously it couldn't have been self-defense. But also that subjective belief, no matter how genuine it was, has to be objectively reasonable. So a hypothetical, reasonable, and prudent person in those circumstances would have shared that belief. What that really means is that your fear can't be speculative. It can't be, for example, well, for all I knew, that guy could have had a gun, or he could have had a knife. That's a speculative fear. That's not a fear based on evidence, things that you're observing. That's different than if someone's reaching for their waistband where they might keep a weapon. Their reaching for a waistband is an observation. It's evidence from which you might make a reasonable inference that they're reaching for a weapon. But you need something like that. It can't just be speculative or imaginative fear that you're defending yourself against. And unfortunately, or not, depends on how you look at it, I suppose. As a criminal defense attorney, I think it's unfortunate. Prosecutors in America have basically unlimited discretion on who they want to bring to trial, who they want to charge, prosecute, and bring to trial. There's virtually no checks on that. In theory, we have a grand jury process. It's nonsense. The grand jury returns an indictment if the prosecutor wants an indictment. That's just the practical realities of how it works. So if they want you to go to trial, you're going to go to trial. And if you do go to trial, the expense is almost unfathomable to normal people. So in a killing case where you've killed someone, you're facing a charge of murder or manslaughter, it's common to burn through $200,000 plus in pre-trial expense before you ever get to the actual trial. You point a gun at someone, say back, I'm prepared to defend myself, and they run away, and then after they run away, they call the cops and say, that dude pointed a gun at me for no good reason. You're facing a charge of aggravated assault with a deadly weapon. Your lead counsel is going to want a retainer on the order of $30,000 for pre-trial expense. That's a pretty nice car at $30,000. So these things get expensive very, very quickly, and the prosecutor decides if you go. And by the way, if you go to trial and you spend hundreds of thousands of dollars and you get acquitted, which means the jury decided what you did was not a crime. It was lawful self-defense. You think you get any of that money back? Not for me, you don't. No, So, and of course, as I said before, the risk of getting convicted is never zero, no matter how innocent you actually are. And the criminal justice system is not about truth. In fact, when you think about the phrase criminal justice system, the most controlling word in that phrase is system. It's a system. It's a system for the bureaucratic administration of the criminal law to people. It cares about you as a human being, not at all. Most of the clients I work for, they look at me and they say, I can't believe I'm getting prosecuted for self-defense. Because they're normal human beings, and then they know, or at least they believe, they were acting in lawful self-defense, and they can't believe the criminal justice system is supposed to go after criminals, not people like me. Well, the criminal justice system doesn't know you're not a criminal. They don't really care that you're not a criminal. In fact, that's the second most powerful word in this phrase is criminal justice system. It's a system optimized to deal with criminals. The vast majority of the people going through that system are, in fact, criminals. And that's what they're used to seeing. And by the way, 99% of claims of self-defense are nonsense. They're BS claims of self-defense by bad guys who used force against other people for no good reason, but they're lawyers raising the legal defense of self-defense because that's what you do as legal counsel. That means 99% of the claims of self-defense that a prosecutor sees or judge sees, they're nonsense. So what do you think their predisposition is going to be when they hear you're claiming self-defense? That you're just another one. You're the 100th guy coming through this week who's made the same nonsense claim as they're concerned. So they don't know you. That's one of the reasons there's at least a 10% chance of conviction. Again, just noise in the system. And because they don't know you, and obviously they were not there, when you were attacked, when you had to defend yourself, was a uniformed cop standing next to you? No, that's not when that happens. Was the prosecutor there? Was the judge there? Was the jury there? None of these people were actually there. They don't have any personal knowledge of whether what you're claiming is true or not. So they're hearing stories. They're hearing a story of guilt from the prosecution. He's describing, in our view, this is what happened. And then they're hearing a story of innocence from the defense. And if anyone here served jury duty? A few of you. So you were told that you have to arrive at your verdict based solely on the evidence and legal arguments you hear in this courtroom. That's just another way of saying we're going to tell you two stories and you have to decide which one you believe. Right? So it's all storytelling. That's how you could get sent to prison for the rest of your life because the jury decided the other guy's story was better. The prosecutor's story was better. So a lot of risks there. The good news is that as much as prosecutors like to win, and they're in it to win it, if they've brought you to trial, they want you convicted. They're not there to lose, okay? If they thought they were going to lose, well, that's the good news. If they thought they were going to lose, if they thought there wasn't a very high probability of winning, you're probably not going to trial because they have 100 files on their desk that are all easy convictions. Most prosecutors, their conviction rate at trial is well in excess of 90%. Why is that? Is it because they're great lawyers? Well, sometimes they're great lawyers, but it's mostly because most of the people they're prosecuting are, in fact, criminals, and they choose the cases to bring to trial. They don't take the hard cases to trial. You can think of that 90% conviction rate as their professional grade. They want to maintain that very high conviction rate. That's the good news for us, because if you look like you're hard to convict, you're much less likely to get charged, prosecuted, and brought to trial in the first place. And that's what we want to look at. When that prosecutor's thinking about the 100 files on his desk, if he's prioritizing them from easiest to convict to hardest to convict, you want to be in the bottom of that stack, because those are the people who get their charges dismissed or who get put into a diversion program. If they keep their nose clean for a certain period of time, then the charges go away, which is not hard for people like us to do. So we want to make ourselves, that's our mission. Here we're learning how to make ourselves an unattractive target for attack, right? And a hard target to kill, should we be attacked. Well, legally, for the legal fight, we want to make ourselves an unattractive target for prosecution and hard to convict if we are prosecuted. That makes you less likely to be convicted, prosecuted, even charged in the first place. Another thing to keep in mind is there's a number of cliches that people will say to themselves to not have to think about this stuff. Like we don't like to think about wills or health care or things like that. One of them is, better to be judged by 12 than carried by 6. Whenever I hear that, of course, that's literally true, right? It's better to be at trial than to be dead. But I always ask people, I say, well, have you met the 12? I mean, have you met a jury? Because they're not a jury of your peers. We hear this phrase, jury selection. I don't get to select a jury. If I got to select a jury, I would never lose. I have a modest ability to deselect individual jurors. But I'm stuck with the jury that's sent to me, by and large, from the community. And if they've been propagandized for a year or a year and a half about how you're some monstrous killer in the news, they walk into that jury room with that preconception. I don't care what they say during the jury selection process. So a lot of people also have the notion that, well, if I get in trouble, I don't want to learn this legal stuff. It's technical, it's complicated. If I get in trouble, I'll just hire a lawyer. That's what lawyers are hired to do, is to solve legal problems. And I appreciate the vote of confidence, and that is, in fact, what we're hired to do. But the truth is, we don't have a time machine. I can't go back and change what you did. If you give me bad facts, if you made bad decisions, we're stuck with those decisions. It's going to be a difficult legal case. On the other hand, if you made good decisions, if you made legally sound decisions because you knew where the legal boundaries actually were, well, then we can have a very robust case. We can make you look extremely hard to convict, less likely to get charged, prosecuted, and convicted. So that's the key. Give your lawyer good facts. But you don't give your lawyer good facts out of just goodwill or aspirations, just like aspirations don't win the gunfight for you, right? So you give your lawyer good facts when you know where the legal boundaries actually are, and you make sure you're staying well within those legal boundaries. So what are we doing here this weekend, these 4 days? We're preparing for the physical fight. What do? We get tools, we get training, and we practice, right? The tools here, mostly the gun. The training is what we're doing mostly on the range. And hopefully when you leave here, you're going to practice, right? If you don't practice the skills you learn here, they just evaporate. Well, for the legal fight, we need to do the same thing. Tools, training, and practice. The tools is knowing what the law is. The training is keeping that knowledge fresh so it's actionable for you in the moment. And the practice is making sure you're keeping up to speed on how these things are actually applied to real people in the real world. Collectively, this is how you make yourself hard to kill and hard to convict. The good news is it's not hard to be hard to convict. I already talked about the 5 elements of self-defense. There's not 500, there's not 50. It's really rather straightforward. The key is you have to actually program it into your mind in a contextual framework. So it's like the difference between going to your local indoor range and shooting on a square range at a bullseye target 1,000 times and thinking you're prepared for an actual fight with a gun. What gets you prepared for an actual fight for a gun is the stuff we're doing here today, right? It's contextualized in the physical context of an actual fight. So by actually understanding the real law of self-defense, that makes it actionable in the moment of crisis. You know how it applies if you're the victim of an armed robbery at a gas station, or someone's breaking into your car while you're in it, or kicking in your front door, or you turn a corner and you see a couple of people in a fight. What do you do in those circumstances? Well, I'm not telling you what to do, but I'm telling you ought to think about it now. And you ought to know where those legal boundaries are. Because if you're trying to think it through in the crisis of the moment, do we make better decisions under stress or worse decisions? Generally worse. But if you've thought it through in your mind, if you visualize this within the context of real-world use of force events and how the law and legal system handle them, can you make better informed decisions in the heat of the moment? You should know, really, what you're prepared to do that's legally sound long before the event ever happens to you. Again, the harder you look to convict, the less likely you are to be charged in the first place. Prosecutors have plenty of easy-to-convict cases. You just have to look like not one of them. Look like a hard-to-convict case. And the strategy we've developed at Law of Self-Defense to help all of you do this is what we call learn, maintain, guarantee. Learn what the actual law of self-defense is, maintain that knowledge over time so it doesn't just evaporate, and guarantee yourself world-class legal expertise. So we have a package we've put together for all of the CarryTrainer community here at S12, and I guess this video will be on your YouTube channel. So for anybody watching this on Mickey's YouTube channel, it'll be available for, I don't know, a few months after this event is typically how long we leave it up. So learn. How do you learn the actual law of self-defense without having to go to the law library and read a bunch of statutes, case law, and court decisions? Well, we have an entire panoply of courses that we've produced. We have a live class we teach twice a year, full-day course. That's our advanced course. And in this bundle, we include a ticket to that course. We have state-specific courses available on DVD and online streamed, and we provide 3 of those, any 3 states that you want for those state-specific laws. We have a course on defensive property, meaning both highly defensible property like your home, business, occupied vehicle, as well as personal property, things like pets. We have a course on defending yourself in a riot, looting, and arson situation. Wouldn't surprise me if we begin to see more of those coming in the next year, given the election results. We have courses on picking self-defense insurance, what to look for, strengths and weaknesses, different characteristics. There's a number of these programs out there. CCW Safe is here today. I happen to be a member of CCW Safe. It's the best fit for me, but different plans come in different flavors. What's the best fit for you? Well, we help you make an informed decision with this course. And then we have my book. Look, how many people here have my book already? A bunch of you. Anybody ever buy a book for someone else or give a book to somebody else? I see a bunch of hands go up, right. So we give you 3 copies of my book, the printed physical book, as well as an Audible version and a digital version you can have in your Kindle so you can read it anywhere you are. And I think that's all of those. So all this stuff, all these courses, the book, the live course, all together would be $2,000 worth of stuff, and we include it for free for all of you here today and watching this on CarryTrainer's YouTube channel. So that's how you learn this stuff in the first place. But how do you learn it in context? Well, that's what we call the maintain step. Every week we produce 5 or 6 videos where we apply that law of self-defense to real-world use of force scenarios. The Daniel Penny situation in New York City, for example, the Apple River stabbing that happened in Wisconsin a while back. So you don't just learn the black letter of the law, but you see how it's actually applied in real courts to real people who've had to really act in self-defense. And we do this continuously throughout the week in YouTube videos, members-only videos, podcasts. So every week you have access to content that's refreshing your recollection, not just of the law, but how it's actually applied. And the last step is really, in my opinion, the most important step, and that's to guarantee yourself world-class use of force law expertise. And this is the world-class use of force expertise. That's me. My legal practice is a consulting practice, so I don't represent clients directly, but wherever any of you would be involved in a use of force event, you would retain local counsel, and my client is your attorney. I provide a legal consult to your attorney. We have almost 100% success rate in getting charges dismissed. People put in diversion programs or getting acquittals at trial. We have an extremely high success rate. But we only provide legal consults to people who are our platinum members. So we have a low-level membership that only gets access to content, and then we have our platinum membership. If you're not a platinum member, we don't do a legal consult on your case. And I can tell you, I get calls every month from lawyers who want me to consult on their cases, but if their client's not a platinum member, we can't do the work. I also get calls from people who are platinum members. We had a case earlier this year, I should say. In February, we get a call from somebody, a platinum member, involved in a stabbing. He's getting prosecuted. And he'd been a platinum member for 6 weeks. 6 weeks. So we'd collected a total of, I think, $30 from this guy. And now I'm providing a $10,000 legal consultation on this case that he gets for free. And it's not just providing the consultation for the trial, it's being at trial as an expert witness if that's needed. Heaven forbid you're convicted. If there's an appeal, we also consult for your appeal process all the way through until every possibility has been exhausted to justify your use of force in self-defense. So that's the nature of our practice, and we only do it for our platinum members. We don't take outside consults. We haven't for several years now. And the platinum members get that for free. There is no additional charge for anything I just described to you. Normally, it would have been a minimum of $10,000 to retain me to do a legal consult on our case. That's our base retainer. So that gets me on your legal team. It also vets your legal team. So I can tell you, I've worked with a lot of good criminal defense attorneys. None of them are perfect. And none of them have a lot of experience with good guy cases of self-defense, because good guy cases of self-defense are relatively rare compared to all the claims of self-defense. Like I said earlier, most claims of self-defense are bad guys, just raising BS claims of self-defense to try to escape liability for what they've done wrong. Criminal defense attorneys will have a lot of experience doing bad guy cases of self-defense. But you talk to most of them and ask them, I've asked them, hey, you've been a criminal defense attorney for 30 years, 40 years. How many good guy cases of self-defense have you had in that period? And they'll say 3, 4, maybe 5. You get very good at doing something 3 or 4 or 5 times over 40 years? Probably not. And they know they're not. That's why I end up getting retained to consult on their cases, because all I do is good guy cases of self-defense. So the $2,000 worth of courses, the books, the live class that we teach, a standard membership that gets you access to all our online content that we produce every week, having me guaranteed available to you to do a legal consult on your case for 5 years, a 5-year period where you're a platinum member. Normally that would be $5,000 worth of services from law of self-defense. Well, we've put together this year 30% less than we did last year when we were here, is $9.99 for that package of services. That works out to 55 cents a day, folks, over a 5-year period. So I don't tell people what to do. I'm not telling any of you what to do. But if you look at our content, you like it, you see my book, you like it. Some of you here already have the book. You raised your hands. You can tell other people about it. If you think it's trash, though, silence is golden. So the This is the best offer we've ever put together for all this stuff, and you guys are getting it first. Now, there's no particular time limit. There's no particular limitation. Frankly, I think the time limit is kind of inherent. You guys could be driving home from this event right now, or on Monday, I guess, and get involved in an event, right? A use of force event where you have to defend yourself. That guy who called my office, he'd been a member for 6 weeks. If he'd spent another week thinking about becoming a member, he would have been out of luck, because I wouldn't have been able to provide him with a legal consult. So you have to decide, do you want to be covered now? Because it doesn't work retroactively. And that is what I have for all of you.